Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Let's have a look at the law of tort. A tort is just a civil wrong other than breach of contract. The concept of tort is based on social responsibility. The idea that somebody who commits a tort, we call that person the tortfeasor, is required to compensate a victim. There are many different types of tort, and in this section of CyBOK, I've written about the two that I think are most significant, the law of negligence and strict liability for defective product. There are many other types of tort. The tort most people will be familiar with is the tort of negligence. Now, whether or not negligence exists is usually a function of two different questions. Does that person owe a duty of care to the victim, and have they fulfilled or breached their duty to the victim? It's helpful if you tease these out and look at them separately. First of all, when does one person owe a duty of care to another? One core concept that comes up time and time again is this idea of foreseeability. If you think of a given activity that somehow revolves around cybersecurity, ask yourself the question, if I'm not careful in what I'm doing, who might be harmed as a result? Outside my immediate sphere, or people outside my company, people in other places around the world, who might suffer some type of loss? As soon as you can imagine that kind of connection, that's a strong indicator that you might owe a duty of care to that foreseeable victim. I've given a number of examples for you to consider in a table in this section. I'm not suggesting that all of these parties always owe duties of care all the time, but nonetheless, I would urge you to have a look at it and think through when you're making decisions as a practitioner, if I get this wrong, who might suffer? If you owe a duty of care to another person, the law doesn't normally hold you to a standard of perfection. After all, negligence is about finding fault. There's a recognition that sometimes accidents happen, sometimes bad things happen, and it's not your fault. So we don't ask people to act perfectly, we ask them to act reasonably. Now that, of course, leads to a problem. How do you prove that someone has acted unreasonably? What is a victim supposed to do? The concept of acting reasonably or unreasonably is one that a judge or a jury will assess by reference to whatever social framework they've got at the time. When I'm in a room full of cybersecurity practitioners and I describe a case study where someone has made a decision or someone has carried out a cybersecurity activity, and I ask the question, do you, a room full of practitioners, believe that this person acted reasonably or unreasonably? It's interesting to see how often the people in the room will converge to a single opinion. The problem with that standard, though, is that it just suggests that so long as we all do the same thing, so long as we all convince ourselves that what we're doing is the right thing, then maybe that's enough. And of course, people have commissioned any number of studies, best practice studies, asking the question, what do people in my position in other companies do? Now, why are those studies commissioned? Because people are trying to get a sense of how much am I required to do. We're trying to find out, are we acting reasonably? Now that leads to a problem. If everybody in a given environment is slow to change, if the environment around you is changing, but you and other people in your group are not changing with the times, that could lead to a situation where everyone is really not doing right as that is defined in a given place in a given time. A famous U.S. judge in the 1930s was confronted with a case like this. Someone towing a barge did not have a working radio. The question was, why don't you have a working radio? And the answer is, well, none of our competitors, most of the people in our industry are not required to have them. And the judge came up with this observation: common practice is not the same as reasonable practice. Just because everybody else is doing it, just because you're right in the median of that bell-shaped curve from a best practice study, does not necessarily mean you're going to get away without liability if something goes wrong. That same judge later was asked to try to give some guidance on, well, how do we know when we have to shift? How do we know when it's time to jump into the next new technology, into the next new operating procedure? And he put together what is kind of a cost-benefit analysis, where he said if the burden of this new technology, the burden of this new methodology, is less than the harm you're trying to avoid, and that's the probability of loss multiplied by the amount of the loss, then you have an obligation to pick up that new technology, you have an obligation to take on that new methodology. Very famous cases, you can read about them, there's been a lot written about these. Those two frameworks that I've just given you are essentially static. The rules that I've just described about does one person, a duty of care, do they owe a duty of care to another party? Have they acted reasonably? Those basic concepts have not changed very much in hundreds of years, but nonetheless, they produce dynamic results. The results change. Why? Because if we look at duty of care, for example, our concept of foreseeability grows with experience. As we get more experience in the world of cybersecurity, we begin to see circumstances where our mistakes might create harm for other people. Similarly, our concept of what is reasonable also changes. It's also grounded in social expectation. So both of these things change over time, and both of these things can differ from society to society. Now, some people look at that and they say, hey, I don't think I'm going to have a problem because I live in a place, I live in a society where the courts are not very aggressive. We don't have a liability society. That's just for the common law people. It's just for the folks in California. Do be careful. If you do find yourself sued under a theory of negligence, your conduct may well be measured by the standards of the territory where the victim is located. And that's because of private international law, and there's a note on that in Section 7. Product liability, or more accurately, strict liability for defective products, is very different from negligence. Under certain circumstances, we want to hold a manufacturer liable if they have created an unsafe product, and that unsafe product results in death or personal injury. In this area of the law, the focus has moved from fault of persons to flaws in a product. So it's no defense to a product liability claim to say that we spent a lot of time on engineering, we spent a lot of time trying to make the product safe. Trying really hard is not good enough in this area of law. Originally, when I started teaching legal aspects of cybersecurity, I wasn't terribly concerned with product liability because it's limited to discussions of death or personal injury. As the Internet of Things has become an increasing phenomenon, though, this area of law is starting to become more relevant. People are thinking about this area of law much more often. Why? Because we've entered an age where cybersecurity failures can lead to personal injury or death. The most common case that people like to talk about is what about self-driving automobiles that go wrong somehow? But on a more simple example, you could just look at a remote-controlled thermostat. If somebody were to break into that and alter the temperature of a home of a vulnerable individual, that could result in personal injury or death. Remember, though, that strict liability for defective products only applies to products as defined in this area of law, and software on its own is not defined as a product. So here's how this works out. If somebody creates unsafe software or software that has a flaw, and that software is then inserted into a piece of hardware which is sold as a product, and the resulting hardware product is unsafe, then whoever manufactures and sells that hardware product will be strictly liable for having sold an unsafe product. But the supply chain partner who produced only software will not be strictly liable under this theory of law. This is one of the reasons why in manufacturer products that have complex supply chains, a lot of attention is given to contractual negotiations about how to shift this liability back and forth. With torts generally, it's up to the victim to prove that they have suffered what we would call a cognizable loss, a loss that the law will compensate, and they have to demonstrate that that loss was caused by the tortfeasor's action. So the tort itself has to be causally linked to the loss that's provable. And there are cases, especially in cybersecurity, where proving that can be a serious challenge. Now remember, anytime a victim has a serious challenge proving a loss, going back to our risk equation, that probably lowers the potential for risk to the tortfeasor. Because of difficulty in calculating damages in some circumstances, occasionally lawmakers will simply write out a tariff of compensation under certain defined circumstances. This happens, for example, in the U.S., where certain types of copyright infringement can be subject to so-called statutory damages, and also in the state of Illinois, when they passed their law concerning use of biometrics, violation of that law results in statutory damages of fixed amounts. Also, if you're going to be in contact with the U.S. legal system, you must take care to remember about the possibility for punitive or exemplary damages. These are special damage awards designed specifically to punish, let's say, especially careless behavior or sometimes indifference to human suffering. And those types of awards can be many, many multiples of the underlying award for quantum of loss. Within torts generally, when you have more than one tortfeasor or more than one party involved in committing the tort, there are a number of different rules about attributing and apportioning liability. I've mentioned two here. The first is vicarious liability. The most common place you encounter vicarious liability is when an employee does something negligently or commits a tort. If that tort is committed by the employee within the course of their business, then the employer becomes strictly liable to compensate the victim. The case that I've cited here is one that I mentioned in CyBOK. I mention it here because after version 1.0 of CyBOK was published, the UK Supreme Court did make a change in this area of law. It's not a significant change for purposes of analyzing what can go wrong, because the court did confirm that yes, vicarious liability can apply in data protection law. That's not terribly surprising. But they said if we look specifically at what happened in this case, and it's an interesting case, I would recommend you have a look at it. The employee, the internal auditor, who violated data protection law was not acting in the scope of his employment when he undertook this malicious act. He basically disclosed everybody's personal data to the world. He was specifically trying to be malicious. He was off, said the Supreme Court, he was off on a frolic. When an employee is not acting within the scope of their employment, then vicarious liability doesn't apply. So yes, this doctrine does apply to data protection law, no surprise there, but in this particular case, the employee was off on a frolic because he was acting maliciously, not within the scope of his employment. Secondly, I've mentioned joint and several liability. And as I've said here, a small percentage of joint responsibility can lead to 100% of liability. How does that happen? Imagine if there's more than one joint tortfeasor. Let's say your company and a second company are both involved in doing something that harms an individual or a group of individuals, financially or in some other way. Well, you can say, I'm only partly responsible, so we have to share responsibility. What if the other party goes bankrupt? Or what if the other party can't be found and drawn into court? Joint and several liability is the doctrine that says, even if you only caused part of the problem, you might end up having to pay all of the liability. Now let's look at the